Hey everyone, welcome back to another episode of Law Scholars. We are continuing our discussion on criminal procedure, and we are moving on to full searches and seizures. We just covered brief searches and seizures. Now we are going to be focusing on full. And to start with that, this episode is going to be based on warrants and what is required for a warrant, why they're important, and why we need warrants in the first place. So, what are the requirements for warrants? Let's go ahead and start with that, and then we will give some historical context, and then talk about some of these requirements in more depth. This is going to be a longer episode. There's also a lot of cases here, a lot of factual details. My notes are going to be a little bit more sporadic, and so just be aware about that as we get into it. But expect this to be a longer episode. Warrants it's a lot of material. Okay. So a valid warrant needs first probable cause that is made under oath with particularity and is signed by a neutral magistrate. So those are your four requirements: probable cause made under oath with particularity and signed by a neutral magistrate. I just want to outline that before we get into any of the historical context. Why ultimately do we have warrants? Well, a general search warrant was something that was common practice in the British Isles before the Revolutionary War in the United States. These were warrants that were authorized by the king to conduct a search. There was no limiting language in these warrants. Anything, anywhere could be searched, and there was no expiration date on these warrants either. The same was true for writs of assistance, where these were custom officers who were allowed to conduct searches on colonial ships in the United States. With this background, you can see there is no limitations to general search warrants at the time of the Revolutionary War. And so when our Constitution was being drafted, ultimately, we wanted to correct those issues and flaws with general search warrants. We have an example here. This is Entick versus Arrington. This was a case back in England, back in the day, a long time ago. What happened is that there was a search that was conducted, and a lot of possessions were destroyed in the search, and it was authorized by one of the Parliament lords at the time. This type of search, a general search, was at this point not authorized, not supposed to be authorized by the Lord, because people need to be protected in their homes. Otherwise, there's going to be disorder, and the government would end up falling away. So this case ultimately decided that general search warrants were no longer valid in England. Let's talk a little bit more in depth about a writ of assistance, which I had just briefly mentioned. A writ of assistance authorized representatives to search ships for any concealed goods that might be owed to Great Britain. It required deputies and other servants to assist in the search, and the search could be conducted at any time, any place, day or night, and it expired on death of the king. That was the only limitation on a writ of assistance. Once the king died, the writ of assistance expired. And that's not really a big limitation, especially considering how, people live for a long time a lot of the time. Okay. So as general became less popular in England, they were still being utilized more often in the United States, and I think this is largely based on England's desire to control the colonies at that time, as the general search warrants were being increasingly issued, much to the detriment of those citizens. General warrants and writs of assistance led to several distastes amongst the founders, and there are several reasons for this. I mentioned a couple already, but biggest ones is there's severe potential for abuse. It's because there's no requirement for probable cause, there's no limits or anything like that. There were no remedies for any of this because the existence of this warrant was valid. And then also there was no distinction between general warrants as well as writs of assistance, and both of those were bad in the first place. So that was just a lose-lose situation. So even before the Constitution was developed, several colonies stated that general warrants ought not to be granted. And during the Constitutional Convention, many delegates refused to sign the document unless there was the promise of the Bill of Rights. And shortly after ratification, the Bill of Rights was drafted, and it included the Fourth Amendment protections. And those protections say that individuals are secure against unreasonable searches and seizures. And it also says that warrants are only going to be allowed if there's probable cause, and those areas that are to be searched are stated with particularity. So let's actually discuss what particularity in warrants looks like. This particularity requirement is what distinguishes a valid warrant from an invalid warrant. Once you have probable cause, you need to state with particularity what that probable cause and where you get it. And so our first case here is Wheeler versus State. Well, this case created a new test. Let's talk about what the old test was. The old test was described in Marin, and it said that the warrant cannot leave the officer with any discretion about what the warrant covers. So, a pretty straightforward test there. But what the new test says is warrants, in order to satisfy the particularity requirement, must describe what investigating officers believe will be found on any electronic devices as much as specificity as possible underneath the circumstance. And a lot of this test is talking about electronic devices because most often now electronic devices are going to be what are searched. And if you're going to be searching an electronic device, you need to be very careful and state with very specific which electronic devices are going to be searched and what parts of those electronic devices are going to be searched. In other words, the court in this case is asking whether it is reasonable to provide a more specific description of the items at the juncture of the investigation. This test, the one I just read, can be compared with the Still test, where the warrant must be specific enough that the officer with a reasonable effort can identify the described location of the search. So, some common principles to abide by. These include establish a time frame for when the crime was committed. These are things that are going to be put on to the warrant. The affidavit for the warrant in that application. The time frame for when the crime was committed. If the device wasn't used within that time, well, then the device wasn't involved in the criminal activity and should be excluded from the search. It should state the crime associated with the search. This way, investigators can narrow searches of electronic devices on files that are actually relevant and related to the material of the crime. And then the warrant should be limited to only include those types of media files that are associated with the crime. So these could be written files instead of video files, just depending on what exactly the crime was. For computers, the description of items also need to be more specific. Officers searching for evidence about witness tampering. In this case, the officers were searching for evidence about witness tampering because the defendant was trying to prevent a family member from testifying against him. And by searching the computers in this case, that was kind of outside the scope of evidence of witness tampering. We have another case, Buckner versus United States. In this case, an informant made an illegal purchase and described the location of the apartment where the purchase was made. This is a classic way of trying to develop probable cause. Once you have an informant who makes an illegal purchase and then tips the officers off about that, or the officers could ask the informant to make that purchase and then describe the apartment. Well, in this situation, the informant made the purchase and described the location of the apartment to the officers. The officers filed an affidavit and submitted an application for a warrant using the description that was used by that informant. But after obtaining the warrant, the officer went to the apartment building and they discovered that the description that had been provided by the informant was backwards. Things were a little confusing, a little messed up. Things weren't said as clearly as they could have been. Well, the officer in this case kind of took an educated guess to determine which apartment complex was the one where the crime had actually been committed, and was correct in their guess. But this warrant was challenged based off of the incorrect information that was included on the warrant. Well, what happened in this case is the court said that this is still a valid warrant. Using the still test, a reasonable officer would be able to identify the location that was described in the warrant. So what happens if that would have been invalidated, if the officer wasn't able to describe the location? Well, then you'd still have to, at this point, that would be thrown out, and then you would look to see if there's any other evidence of probable cause, and then you would need to get a new warrant. And you can see Maddox is the case for that. Okay, so we talked about particularity in the actual warrant. What is going to be the basis of getting a warrant? And this is probable cause. So in our previous discussions on brief searches, we talked about reasonable suspicion being the actual standard that is going to be used to determine whether or not a stop or a search. A brief search is going to be justified. I don't want to confuse words. When it comes to warrants, getting a warrant, you need to have a probable cause. So the standard for probable cause can be articulated with 4 elements. Each part of these elements, probable cause, the definition varies from jurisdiction to jurisdiction, but generally this is going to be the idea that we have. First element, the assessment must be made in mind of a reasonably prudent or cautious person or police officer. Second element, inferences need to be strongly associated that a crime is or has occurred. Third element is that the comparison to standards, this is more than reasonable suspicion, but it doesn't extend to the level of certainty. And then the fourth element is that the information obtained is provided by a quality source, either an informed a type of informant, or by the officers and through cooperation of informants, or officers witnessing the crime themselves. Okay, that's our standard, and that's going to illustrate our discussions over the next few cases. Our first case is, forgive my pronunciation of this name, I think it's Breingar versus United States. This goes ahead and gives our definition of probable cause. Probable cause, as I mentioned, is not beyond a reasonable doubt, but it is beyond a mere suspicion or reasonable suspicion. The definition that this case provides is where the facts or circumstances within the officer's knowledge and of which they had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that the offense has been or is being committed. So, officers have a particular kind of knowledge. That knowledge was obtained by a trustworthy source and a man of reasonable caution in that belief that a crime has actually been or is being committed. The facts in this case, Breingar versus United States, is very similar to facts that are presented in Carroll. In Carroll, the court found that the officer's knowledge of criminal activity and the defendant and the nature of the location and the place where the type of crime was actually actively ongoing, all those factors together combined gave rise to probable cause. Here, there is very similar facts, but there's no distinction besides a statute and minor discrepancies that was actually used in the application for the warrant. All these things gave a lack of error when the defendant had the defendant was denied a motion to suppress evidence or suppress evidence that was obtained based off of a warrant. In other words, it was a valid warrant. There are a couple of additional rules I do want to mention. First, police can use their training and experience to establish probable cause. So the more experienced an officer is, the more likely they are to find probable cause. And then second is called the fellow officer rule. Officers can use a collection of knowledge to create a probable cause. So there's no need for each officer to have probable cause. An officer A can have a tidbit of information, Officer B can have a tidbit of information, Officer C can have a tidbit of information, and when you combine tidbit A, B, and C together, well then that might be enough for probable cause, and this fellow officer rule allows you to use that information to establish probable cause in your application for a warrant. Okay, so now we have State versus Stevenson. Stevenson was stopped for failure to turn on the blinker in the right moment, but Stevenson was also suspected of drug activity, so this is going to go back to our pretextual stop. He was stopped for failure to turn on the blinker, but they kind of wanted to find some additional information. When they stopped Stevenson, they had a strong smell of alcohol, and Stevenson was asked to step out of the car, and the car ended up being searched based off of that odor, suspecting that there was an open container of alcohol in the vehicle. Stevenson did pass the field sobriety test, but an open container was found in the car. And so now Stevenson is trying to get this evidence of the open container out, excluded, because there was a lack of probable cause. At least that's what he's trying to argue. Under the Bringard test, the odor of alcohol was not enough to establish probable cause. After he had passed the sobriety test, the search should have concluded. So let's talk about this odor of alcohol. This odor of alcohol probably was enough to establish reasonable suspicion. Officers suspected that there was an open container, but without seeing Stevenson take a drink from the open container or actually having the open container in plain view, well then there was a lack of probable cause to actually conduct a search. Because Stevenson passed the sobriety test, it should have concluded. If you fail the sobriety test, well then you have probable cause that there is additional contraband listed in the vehicle, and a search could have been conducted at that point, assuming of course you have a warrant, or if you don't have a warrant, you have exigent circumstances. We'll get to exigent circumstances a bit later. Okay, we have another case, State versus Parent. In this situation, the officers received an anonymous tip that Parent would be arriving at the airport with illegal drugs. This tip was corroborated by the defendant's criminal record and the description. The officers pulled it up once they had this tip off. They looked up Parent's record, saw that Parent had a record for transporting drugs, and it was corroborated with the description, meaning that they were able to pinpoint who Parent was at the airport, and everything had happened in exactly the order that was going on. A warrant was provided on the condition that the flight arrives and that Parent was on the flight. So this is something called a conditional warrant. And it can actually, conditional warrants are a little bit iffy, but they are valid warrants. It's also known as an anticipatory warrant. What an anticipatory warrant is, it's when the officer knows a crime is going to occur, but they don't have the probable cause yet, and so they're going to seek a warrant to conduct a search once that probable cause actually occurs. So in this case, you have a Parent. There's no probable cause yet that Parent has actually committed a crime. We just know that Parent is likely to commit a crime based off of this tip-off. So this anticipatory warrant says conditions when probable cause is actually going to happen. Probable cause happens if the flight arrives on time and Parent is on the flight. So for an anticipatory warrant to be issued, the officer needs to show that there's probable cause of evidence if the triggering condition actually occurs, and second, there needs to be probable cause of the triggering condition. This kind of warrant is allowed under GRUBS, but many of the states, and when I say many, I still mean a minority of the states, they don't think that this kind of warrant should be issued. And the reason for this is because it's allowing the officers to determine when probable cause actually occurs, not the judicial branch, which is the whole point of having the warrant, is the judge is supposed to determine whether or not there is probable cause. Okay, so let's look at the different types of sources that are going to support probable cause. Where can you actually get sources from? Well, these are going to include the police. You're going to have witnesses. You're going to have victims. You're going to have confidential informant tips. A confidential informant is somebody who is known by the police. And then you're going to have anonymous tips, and these are people who are unknown by the police. The courts do mistrust information that comes from confidential informants and anonymous sources, which requires some specialized rules that, well, we'll talk about right now in two cases, State versus Barton and State versus Utterback. And then actually State versus, we've got lots of cases to go through still. But let's go ahead and start with State versus Barton. This test, it's describing the Argulier-Spinelli test. It's a pretty popular test. I just can't pronounce it right. There's two parts to this. First, do they know? When you're looking at the tip that is coming from either a confidential informant or coming from an anonymous source, you have to ask if that informant, do they know what they know, meaning do they have a basis of knowledge, and is there evidence to support the reliability of that test. The issues with this Argulier-Spinelli test is that these prongs were initially independent. There is no way of balancing against the others. You can meet one but not the other, and it would fail. But the standard for review in this case was de novo, and the usual test, the usual standard for review is going to be an abuse for discretion. Essentially, the Argulier-Spinelli test has issues, and so the court in State versus Barton is going to use the totality of the circumstances to determine whether or not that informant is going to be reliable and if they actually have knowledge. So you're going to look at the totality of the circumstances to see if both those prongs are going to be met instead of just one of those prongs is going to be met. In this case, the test, the Argulier-Spinelli test, was not utilized, but it is still highly relevant. You have to make sure that there's a basis of knowledge, that the informant knew where the crimes were going to happen, and or they had a particular idea of what was actually going to occur. It can also show whether or not evidence is going to be reliable based off of knowing the informant's identity, which means if the police know the identity of the informant, it increases that factor of reliability, and whether or not the informant is willing to provide any self-incriminating information, because if the informant is willing to provide self-incriminating information, it's more likely that the information that they're providing about somebody else is also going to be incriminating information. Okay, we have State versus Utterback. In this case, a search warrant requires probable cause on facts that are going to be set forth in an affidavit. If those facts are coming from an informant, probable cause can be established by testing the informant's basis of knowledge and reliability. This is going to be the totality of the circumstances, to actually meet this criteria, which is actually called the Gates test, using the totality of the circumstances. So there are 4 methods to establish the informant's reliability. First, it's going to determine whether or not the informant has given reliable information to the police in the past. Do they have a history of being a confidential informant? Second, whether the informant is a citizen informant, which is a person who is motivated to assist law enforcement. Third, whether the informant has made self-incriminating statements when they gave that information. And fourth, the officer needs to corroborate the information that is provided, regardless of whether or not it's a confidential informant or if it is an anonymous informant. The largest issue in this case is whether or not the informant was reliable. In State versus Utterback, there was no evidence to show that the informant had provided reliable information in the past, and there was no evidence to show that the informant was a citizen informant. There was no self-incriminating statements made to the police, and the officers had only corroborated innocent aspects of the defendant, meaning where the defendant lived and what the defendant looked like, but they did not corroborate any of the criminal activities. So in this case, State versus Utterback, the result was a warrant should not have been issued, and any evidence gathered in opposition to that warrant should have been excluded. Okay, so this is called the Gates test. The Gates test has been adopted in the majority of states because it gives judges a lot more flexibility applying the factors of the Aguilera-Spinelli test. There is also something called informer's privilege, and this is where the name of a confidential informant is not going to be disclosed to the defendant unless if there are some exceptional circumstances. Okay, a few more cases. State versus Ravets. I can't pronounce it. But this was an anonymous tip. And when there is an anonymous tip, the police need to corroborate the information to test the reliability of the tipster. In this case, there was... Sorry. They had received an anonymous tip that said multiple people were going to this individual's home and staying there for a short period of time and leaving and seeing bags of illegal substances with them as they were leaving. So the officers went to the home, they saw people show up, stay for a short time, and that they had left. When the officers ran the plates of those who had left, they discovered that the people who had entered the home and left had some suspicious records. They had criminal records after running those plates, and this was enough to find probable cause. The dissent does argue that they didn't do enough to corroborate the anonymous tip that had come in. There was no additional investigation of the apartment or the visitors that came to the apartment. The officers wouldn't have even known if the tips were coming from the same person because there were multiple phone calls, or if their story was true. So the big difference between a confidential informant and an anonymous tip is that it's much harder to confirm the reliability of an anonymous tip because the only way to confirm it is going to be through corroboration. And that's the whole point of this test, is to see what kind of level the officers need to do to make sure that there is corroboration. Okay, Illinois v. Gates. This is really where the Gates standard is going to come into play. This is where it comes from. This was a situation where the officers received an anonymous tip that Gates and his wife were drug dealers. The wife would drive from Illinois to Florida, where the vehicle at that point would be loaded with drugs, and then the husband would fly to Florida and then drive the vehicle back with Illinois back to Illinois as the wife would hop on a flight and come back. So they'd alternate. The officers in this case, they followed the wife to Florida after getting this anonymous tip. They saw that the husband had a flight scheduled, and the husband did arrive with Florida and noticed him picking up the car. At this point, a search warrant was issued, executed, and an arrest occurred. In other words, that tip illustrated future events very clearly, and those future events were followed very well, almost exactly as it was described. Looking at the totality of the circumstances in the situation, the corroboration was enough to find probable cause. The search warrant was valid, and the evidence of that was discovered in the vehicle was not excluded at trial. Again, we have Alabama v. White. The takeaway in this case is that when the police are responding to anonymous tips, they need to corroborate significant details to show that the tipster was well informed. Again, this needs to be significant details related to the crime, not related to the innocent aspects of individuals' lives, such as where they live or whether or not they look like the person that is being described. Okay, and then we have Florida versus JL. Our takeaway from this case is that when police are responding to anonymous tips, they need to corroborate significant details of the criminal activity, not merely the innocent facts of the defendant. So that is just a further explanation of what I had just described. Okay, our last element of a warrant is that it needs to be signed by a neutral magistrate. We have State ex rel. Brown versus Dietrich. What happened here is that there was a magistrate. The magistrate was related to the police chief, and this magistrate had issued a warrant, and so now it's a matter of, is this magistrate neutral? Well, the Fourth Amendment doesn't include the word neutral, but the Code of Ethics and other statutory mandations say that the magistrate needs to be neutral. A clear violation of a neutral magistrate is going to be an attorney general who issues a warrant, judges leading a search party, and then later or issuing the warrant and then conducting the search party themselves, and then if the judges are getting compensation to actually approve warrants. In this situation, the marriage between potentially conflicting parties, this was not enough to establish a violation, and the reason for that is because the police chief was not the one who had requested the warrant. It was one of the people working for the police chief that had requested the warrant. The police chief had nothing to do with it, and they did not talk about it. Do want to mention, though, that if a magistrate is disqualified by a lack of neutrality, then the judge may still issue a warrant in times of necessity, which means if that judge is not neutral, they may still issue a warrant if it is necessary, and it's going to only be truly necessary if no other judge is available. Typically going to be remote, one judge on call, that kind of stuff. Okay, tons of information. This was over a half hour long, so I thank you for bearing with me. We had a ton of stuff when it came to warrants, tons and tons of stuff. I just want to go ahead and summarize by saying warrants require probable cause made under oath with particularity to a neutral magistrate. And we talked about all our standards there. Probable cause is going to be, the standard for probable cause, the definition of probable cause is defined in Brangar, and it says it's higher than reasonable suspicion, but it's less than certainty. You need to look into the minds of a reasonably prudent police officer, and the inferences made from that needs to be strongly associated with the crime that has occurred or is about to occur, and then information that is obtained needs to be provided by a quality source, whether an officer, a witness, a victim, or a type of informant, depending on whether or not that information is corroborated. Then when we're talking about particularity, you need to say very clearly what is going to be searched and where it is going to be searched. That is more of an issue when it comes to electronic devices. And then we also talked about a neutral magistrate and what makes a person a neutral magistrate and when they might be disqualified. Lots of material. Thank you for your time. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.